our program with the ICR song. Ram, just start our ICR song.
जय जय कृषि परिषद भारत की, सुखद प्रतीक हरित भारत की। कृषि धन पशुधन मानव जीवन, दुग्ध मत्स्य फल यंत्र सुवर्धन। वैज्ञानिक विधि नव तकनीके, पारिस्थितिकी का संरक्षण। शस्य श्यामला छवि भारत की, जय जय कृषि परिषद भारत की। हिम प्रदेश से सागर तट तक, मरुधरती से पूर्वोत्तर तक। हर पथ पर है मित्र कृषक की, शिक्षा शोध प्रसार सकल तक। आशा स्वावलंबित भारत की, जय जय कृषि परिषद भारत की। जय जय कृषि परिषद भारत की।
Respected our director, Dr. K. Singh Saab, chairman of today's session. Our Dr. W.I.P.O, the head crop production section. Madam Dr. Anita Rani, head crop improvement section. All my colleagues, friends, and our today's our guest of honor, Dr. Anushree Gupta, who is the speaker, who will be the speaker for today's session. So let me just tell you about the genesis of this program. As per the directives of ICAR, that all the ITMU ABI units has to celebrate today, that is 26th April, as a World Intellectual Property Day. So this IP, since India is also member of W.I.P.O, that is World Intellectual Property Organization, which is situated in Geneva. And as you know, currently we are having 193 members, the world state members, and we are one of them. And we have joined this W.I.P.O during 1975. And currently we are also member of many treaties, and which all treaties has been administered by W.I.P.O, that is a World Intellectual Property Organization. And this 26th April, all member states of the world has joined the W.I.P.O as far as the patent the convention is concerned on 1970. So that today, 26th April is being celebrated as a World IP Day, and this year theme is Women and IP, accelerating the innovation and creativity. And for that purpose, we are celebrating. We all are here. Thank you very much for joining this session, which is very important. And this 2-hour session, and I am very glad to inform you that we have a speaker, Dr. Anushree Gupta, who has a vast experience in patent, and she is one of the patent attorney, and having one own firm. She is PhD in biotechnology. So let's start her brief biodata. So, Ram, on karna biodata. So it's our honor to all of us. Indeed, a great pleasure. A dignity, Dr. Anushree Gupta, who did PhD in biotechnology, and she is also operating in the field of IP for Indian as well as overseas clients. And Anushree has doctorate in biotechnology and graduation in law. She is a registered patent agent of India, a member of Bar Council of India, and a member of Asian Patent Attorneys Association. Has more than 15 years, 18 years, I think, experience in the area of IPR. And she is advising clients on patents, plant varieties, registration, trademark, copyrights, design, and other IPR related issues. She has published many scientific papers in the field of biotechnology, as well as the related areas in international journals, including the contribution to the legal publication. This is a very brief biodata. So, Madam, thank you very much for accepting our request for delivering a talk, particularly on W.I.P.O, how the women can, empower the IP related issues. So her talk would be for 1 hour. So let us start her talk, and thank you once again, Madam. So please, the floor is yours now. Can you start?
Yeah, good morning, everyone. Wishing you all the very happy World IP Day. And at the outset, I would like to thank Dr. Singh, Director of the Indian Institute of Soybean Research, Indore, and Dr. Mahavir Prasad Sharma, an eminent scientist of the Institute, who gave me an opportunity to speak on my thoughts and my experiences on a very special and close to my heart topic, women and IP, as I'm a woman and also an IP professional. I would also like to congratulate all the women sitting here and joining in this session for their wonderful job in doing professional and personal life together, making a balance. And also, I would like to congratulate all the men who are here to support and standing next to all the women and giving them due respect and regard. It gives me an immense pleasure, and I'm honored that I'm giving a talk on the special day which is celebrated by W.I.P.O as a World IP Day, with the theme Women and IP, Accelerating Innovation and Creativity. Now, this topic has been particularly taken by W.I.P.O this year and also 5 years back in 2018, as women at that time was not being focused as innovators, though they have been creators for several years, centuries back, but they have never been probably taken the steps out to be innovators and get patents in large number. Still, the women entrepreneurs and women innovators are there, but they are increasing, but still the number is very less. So the focus of W.I.P.O today is to accelerate more women entrepreneurs to come forward and do a lot of good work, do innovations, and spread the awareness of IP, of also being IP professionals. So I would also share that to achieve success in life, for I think any person, be it woman or men, particularly for women, I would like to put my viewpoints here, that one has to come out from the comfort zone. One has to take new challenges, explore the new challenges. As already Dr. Mahavir just gave a brief about me, I am a PhD biotechnology and a lawyer. Earlier, I was a hardcore researcher, and I was doing wonderfully in the research area in the field of biotechnology, had published several research papers in refereed journals, and was very happy in that area. Very comfortable zone, was very happy as I was doing wonderful. And suddenly, then I thought, why not to explore new area, which was the IP area, the intellectual property rights, which was at that time was at a very nascent stage. No technical people or people like us who have scientific know-how were entering in the area of law. So it was a stepping stone for me. In 2006 early, I joined one of the leading and oldest law firm called Remfry & Sagar at Gurgaon. And thereafter, immediately, I appeared for an All India exam for patent agent, which I cleared within a few months in 2006. And thereafter, I served and learned a lot of things in the area of IPR, and also was heading the IPR prosecution, patents for biotechnology, pharma, patent searches at Remfry & Sagar, and gave me an opportunity to learn in this area and put a stepping stone here and be an IP professional. So it was a challenge, but I took this challenge and came out from my comfort zone of research and try to explore this area. Now, since I was very interested and I enjoyed this area, I also took path of law. I did my law while doing my job, and I got the Bar Council Association membership, cleared that exam too, and now I'm a Delhi Bar Council member, and also an APA member, which is an association for patent attorney, which is an Asian association. And second thing, what I would like to say, that avoid restlessness, that we cannot do something. You should be confident that yes, one can do it, one to take the challenge and meet the targets, and always listen to your inner voice, not to the other people. And third thing is that one should avoid, not to have a habit of procrastination. That is, one should not postpone the things for tomorrow. So this habit or intentionally, postponing the things for tomorrow is not good for your future career. And lastly, my thought would be that we should take a path which is not simple. You should take a path which is full of challenges, and to know that you're capable to meet your all the challenges what you've taken and be successful in your life. So with this note, I would just begin my presentation, and I would say that maybe I'm a drop in the ocean in the area of IP, but I think boon boon se sagar bharta hai. So I would like that all my friends and my colleague women should understand that one should take the opportunity, come out from your comfort zone and explore the new areas of your interest and take a challenge that you can do it. So the topic today, which I'm going to speak on, is WIPO. Now, WIPO, everybody knows, is the World Intellectual Property Rights. I've given an acronym as WIPO with the title Women Intellectual Property Right Owners. So women should be taken now into consideration as intellectual property owners. They should do wonderful research in the area of science so that their property rights are being owned by them, and the due right should be given to them. Now, why 26 April is celebrated as a World IP Day? Now, WIPO is an organization who is taking care of intellectual property rights, and it has been there on 26 April 1970. And from 2000 onwards, it was decided that 26 April will be observed as a World IP Day. And therefore, from 2000 onwards, World IP Day has been celebrated every year on 26th April. And in 2018, 26th April, the first topic or first theme was taken up by WIPO related to women, where it was considered that it is a power challenge to make the women in this area to come up, put their foot forward. And now, after 5 years, again, the WIPO has kept this theme, that to congratulate them, to make them more, feel good that after 5 years, whatever development has been happened by women in this area should be appreciated. Therefore, this area is, after 5 years, considered again as a theme for celebrating the World IP Day on Women and IP. Now, giving a small background about some of the oldest women who have done wonderful job in getting the research done and achieving the intellectual property. The first woman to apply for and receive a patent was Mary Dixon Keys, who got a US patent in her name in May 5, 1809, which is way back long, for a process for weaving straw with silk. And interestingly, this process was taken up by a New England company to make hats. So it was a commercial process which has been taken up by a company to use this process to make hats. So that was a wonderful achievement by Mary Dixon, that the process was patented and also been commercialized. In 1899, a patent was granted to Lydia Gear for inventing medical syringe operated with only one hand. Now, everybody in the medical field uses syringes, and the basic concept of making these syringes has come from her. So it gives a round of applause to her that in the medical field, without syringes, nothing can be worked out. So it was her patent which gave the idea how the medical syringe should be operated. The most prolific inventor in the history of IBM is also a woman, Lisa Secord De Luca, who has more than 400 patents in her basket and a lot of feathers in her hat, being an IP professional in IBM. Now everybody uses computer, and everybody knows that computer has been, made by men. But interestingly to know that without computer program, the computer don't work. So the computer programming was invented by a woman scientist, Grace Hopper, who has done a wonderful job that without the computer programming, even the computer made by men will not work. So the backhand scientist, I would say, or a achiever is a woman, though they don't come into the limelight, but they do wonderful job and need to be patted, I think, at the right time and at the right stage, which is probably lacking in today's world. And therefore, it has been important that women should be appreciated, made them motivated to come out from their nests and also show their caliber that they can do it. Another woman is Tiffany Kovlek, is a woman scientist who invented Kevlar, which is a material which is 5 times stronger than steel, and it is used world over to protect people from bullets. So you can imagine it is such an important invention, such an important requirement that for soldiers, for any soldiers who are fighting in the field, protecting us, can be protected from such a material where, make material which can protect from bullets. So again, behind that, it is a woman. So women in every field, I would say, would explore if they do, and they feel that, yes, they can do it, and they have the caliber, the confidence that they can explore new fields and face the challenges and come out with success. Now, women participation in innovation and international patent filing in 2019. As I told you, in 2018, initiative was taken by WIPO to put women in front and also make them aware that they can be good innovators. So how this challenge has helped in international filing and increasing it, being women innovators. As WIPO report released in April 2019, India has the 7th position among the 20 countries, with 28.3% of international patent filing having women or females as listed among the inventors. South Korea and China are top of the list with 50.2 and 48% respectively. In 2021, the scenario is, again, it has been increased, though the increase is very less. It's only 1% increase from 15.5% in 2020 to 16.5% in 2021, where the inventors' share in the international filing were by women. Only 1/3 of the patent applications listed at least one woman inventor in 2021. So it's a very small ratio. However, at least I would feel that it's wonderful that a small dent has been made by the women in this area. And they are being also trying to put up more efforts to bring out more inventions and become inventors and applicants for the intellectual property rights. In 2021, in top 10 origins of PCT women inventors were China, France, US, Netherlands, Republic of Korea, Italy, UK, Germany, India, and Japan. So I would really feel proud that among the top countries, India is one of them where women have taken steps to be inventors or applicants for filing their research. So I really feel proud, and I wish that this continues in a future prospects for women development in this area. Women in most of the technological fields are there, but mostly in the field of life sciences, women have put more efforts. Women inventors in 2021 participated in all the technical fields. Particularly in biotechnology, their share is of 29.6%, in 29.1% in food chemistry, 28.7% for pharmaceuticals, 25.5% in the area of biological materials, and 25.3% for organic fine chemistry. Now, if you see the growth rate is more in the digital communication by the women, with their participation of 19.6%, followed by computer technology, pharmaceuticals, biotechnology, and medical technology. Pharmaceuticals contribute the most to the overall growth for the women inventors, as women more take up the area of science and life sciences particularly. Women contribution to research and discovery. Now, being a research institute, I'm sure that the women scientists here are definitely doing a wonderful job and doing a lot of good research, which can culminate into an intellectual property. Now, in 2021, applications by public research organizations and universities had the highest share of women inventors, 24.3% from the universities and 23.9% from research organizations. So there is a more contribution from the universities, followed by the private companies. So I would really would like to say that even I look forward for most of the ICR institutes, the CSIR institutes, and other public universities that, or central universities, where women can come up with more research work and more innovations and become good innovators. Indian government initiatives for the ease of IP registration and initiatives for women. Now, government has taken several steps since 2018, and after WIPO took up this challenge that women should also come in front, and their research should also be motivated, and they should also become IP applicants and innovators, and due regard should be given as their IP right should be protected. Now, as per the patent law and the rules which have been amended in 2029, the women entrepreneurs were given the opportunity to become the applicants. They are as single applicants and in joint, and with the reduced fee. They have been given an opportunity to pay the reduced fee as individuals, 80% reduction in fee, so that more and more women get the opportunity to file patent applications, and also to expedite examination of these applications filed by the female applicants. So the government has given the option for all the women who are applicants, or at least if they are doing a joint application with the other male member as individual, then also the government gives the option to expedite the application for examination, and also give a reduction of fee by 80%. So with this giving option, India sees a 4-4 increase in patent and also in trademark registration during the last 5 years. India is also ranked in the global innovation index from 81st position to now 48th position. So a lot of development has been happened in India, and India is now improving, and it is considered as one of the upcoming country for the global innovation. Every application is now processed online. If you begin from the start to the finish, everything can be now done online. Even the hearings are done through video conferencing with limited physical exposure to the patent office. So it gives an opportunity even to women, don't have to go to the patent office physically, and can also do the work online. Now, I, being an IP professional, have to do all the work online. Needn't go here and there and spend time and energy to get the work done. So I think it is a very good initiative taken by the government of India to consider the kind of women, how women balances both, personal and professional life. So considering that, I think the government of India has taken a wonderful initiative to keep everything online, and it becomes easy for everyone to handle the applications from the filing till the grant. Also in trademark area, there have been enormous forms. There were 74 forms which confused people how to initiate. They were scared whether we should file a trademark or not, seeing such a cumbersome type of forms. So government has changed the rules, and after changing the rules, it is only 8 forms consolidated, which helps in trademark filing. So it has become very easy for any innovator to get their trademark registered. And also it has become very quick. It's a matter of even 3 months or sometimes a month if no examination report is not challenged, there's no opposition, that maybe even in 1 or 2 months, a trademark is registered. E-filing has increased from 30 to 95%. The number of patents even granted in 2015-16 were just mere 6,000 versus in 2021, it is almost 28,500. And trademark even registration has shoot up enormously in 2021 with 2,55,993. Similarly, even copyrights have been increased a lot from just mere 4,000 to almost 4 times, that is 16,000. There have been opportunities even at the student level for both men and women. Scholarships are being given to the students who are studying intellectual property law. Even to have some technical know-how, the government has also sometimes engaged faculty from renowned institutions on part-time basis to help the patent examination process. And several activities are always going on, and they are increasing day by day to make more efforts on IP awareness, because there are places still who are aware, but they are still not 100% sure whether this IP can help them in life or not, whether these opportunities can help them in their progress of life. So IP awareness is very important, and it is initiated by government every now and then. And today also, if you see, I've got here one presentation and other 2 presentations in the later day for the area of IP. So government is taking several initiatives for IP awareness so that people take good care of their innovations and become wonderful innovators. Now, just a viewpoint how the patent process takes place. A patent application is filed either as a complete specification or a provisional application. A provisional application is something where, being a researcher, your research is in the middle way, your results are still awaited. But to protect your rights beforehand, you can file a provisional application. But if your invention is complete, you are ready with all your results, you can straight away go for a complete specification. Now, after filing the complete specification, there is publication. Publication, you can always request for an early publication. Applicant can file a request by paying a requisite fee at the patent office. However, if you do not wish to have an early publication, the application automatically publishes within 18 months from the date of filing of the application by the patent office. Thereafter, you can also file a request for examination for examining your cases. The applicant has to file a request for examination within 48 months from the date of filing of the application. Now, in between, when the application is being published in the official journal by the patent office, it becomes public, and it is open for the public to view what invention is going to come up. So if somebody has to oppose, if you feel that your work is already been done by this area, and somebody is filing a application before you, then you can file a pre-grant opposition and can establish that you are the first innovator and this invention should be stopped. So there is an option for filing a pre-grant opposition before getting the grant of the patent. And as I already mentioned in my previous slide, that there is expedite examination procedure where the women has been given a special opportunity to file a request for examination for expedite examination. where you get the examination done within months, and your patent can be granted within a year, or maybe few months if the examination report is clear. So this really helps the women innovators to protect their rights as quick and fast as possible. So this initiative has been taken by the government to motivate the women to come into this area more and more and utilize the opportunity. After examination, an examination report is issued by the patent office. Now examination, whatever objections are being taken up by the patent office to be met by the applicant by filing a response. And then, which is to be filed within 6 months from the date of issuance of the first examination report, with the extension of 3 months. So maximum within 9 months, the response is required to be filed for the first examination report. And thereafter, if the controller or the examiner at the patent office is satisfied with your response, the patent is immediately granted. And if you see, even earlier, there used to be an LPD issued, letter patent document used to be issued in hard copies. Now everything is electronic. A patent certificate is immediately issued with a click of a button, and a patent certificate is given to the applicant, either through the attorney or directly. If the applicant is filing directly, they get immediately by email the patent certificate. And even all the, as I told you, all the processes is being now done through e-filing. So everything is digitalized from starting from filing till the grant of the patent. So the process has been highly reduced, and the timeline is highly reduced. And the patent, where earlier it used to take more than 6 years and sometimes even 7-8 years, with a patent tenure of 20 years, if 6 years or about 7-8 years or half of it has gone, then there's no point getting a patent. But now the patents are being granted within 2 to 3 years maximum time. So that is really appreciable by the initiatives taken by Government of India. Now, in the Agriculture Institute like you must be wondering that how we should take protection as IP. Now, method of agriculture and horticulture, as per the Indian Patent Act, is not patentable. So whatever breeding processes you must be doing, or any steps taken in the field to enhance the breeding procedure or making new varieties, are not patentable under the Indian Patent Act. However, there is another system, there's another law, which is the Protection of Plant Varieties and Farmers' Right Act 2001, which has come into picture as a sui generis system by taking the Government of India taking this initiative as a sui generis system to protect the rights of IP by new varieties which have been produced by the researchers, farmers, and due benefit sharing is also being given to the people who have contributed in this area. Even a small contribution is being benefited through this law. So it is a very good initiative by Government of India with this act, that even your new plant varieties, which are by breeding, by even making transgenics, can be protected by this plant variety protection. This authority is in Delhi at the NAS complex, and it has been working quite emphatically to enhance the protection of the plant varieties. Now, what is the role of this Plant Variety Act? It is for the, as I told you, it is for the protection of the new plant varieties, especially the essential derived varieties, extent varieties, farmers varieties. All these varieties can be protected under this law. Safeguard is being taken that no terminator technology or genetic use restriction technology should be there in your varieties which you are coming out with. Then it is also recognizing farmers as innovators, as conservers, as breeders, preserving the plants and plant varieties in addition to cultivators. So it's just not the industry or the researchers, it's also the farmers who have been appreciated and been considered as innovators. IP rights are given to the farmers also in this act. So it is giving the due regard to them too. Simplified procedure is there for the protection of farmers' variety. So as I also told you, that benefit sharing procedure is there. There are avenues, special arrangements are there. They allow individuals or organizations to submit claims concerning the contribution that they have made to the development of the variety, and also allow an individual or an organization to file a claim on behalf of a village or a local community. So benefit sharing can be given to all the people who have contributed to make a new variety. This is a small process brief, a flow chart for how you can go about for the plant variety protection. You file an application where you have to give the seed material if you are protecting the plant variety with the parent and with the hybrid variety. You have to give both the plant seed material and give the DUS fee. DUS is the distinct uniformity and stability test conducted by the plant variety authority at the various DUS test centers. So this has to be given by the applicant, the fee, and DUS test has been carried out twice in a year for 2 years at 2 locations for the extent varieties. And after doing the DUS test, even a single variety, a single difference in a variety, an essential feature, if there's one essential feature is distinct, that variety can be registered under this act. So this is again a very wonderful initiative by the Government of India to help the farmers and initiators in the area of agriculture, particularly to safeguard their rights and protect their varieties. Of course, there are challenges also. There is opposition. And to safeguard your rights, you can also challenge and put forward your arguments that no, your variety is new, and get the registration done. Now, coming to close to my talk's end, I would put forward this Ramayana shlok. Yatra narestu pujyante ramante tatra devata. It means wherever women are honored, divinity blossoms there. जहां स्त्रियों का आदर होता है वहीं देवता रमण करते हैं. तो मैं ये कहना चाहती हूँ आज के वुमेन्स डे पे that wherever the women are doing good initiation on IP protection, doing good research, if the head of the institution, the people who are who understand their women's invention, help them to protect their IP, motivate them, I think their institutes will grow more. And because IP protection is a sign of prosperity. The more IP protection, the more the company, the university, the institutes are prospering. So I would request all my colleagues and fellow members here in the institute to motivate more women research what they're doing, and respect them for all their research and inputs, what they're putting up in this area. So thank you so much for being so patient and giving me an opportunity to speak on this wonderful topic. I think it is endless, but I would love to listen to you and listen and answer your questions. I think with my experiences, whatever I can enlighten you on. Thank you so much. I think the mic is mute. Cannot hear.
Am I audible?
Yes, yes. Thank you.
So again, I'll repeat. I have applied for a copyright. It's, I think, 1 year back, and it's regarding the SQL database. So they couldn't open the database, and I told them that I can help you out because it is a somewhat very specific technical thing. So, but they couldn't open it, so they didn't award me the copyright. And I so many times I returned them, and communications has been done. But as on date, I couldn't get that. That is still pending. Ma'am,
Which form have you provided the data?
Pardon, ma'am?
In which form have you provided the data to them?
SQL database only, native form. Because I wrote them that if you want it to be in some other form, but they said since you are asking for the copyright for SQL database, so you have to provide in the native format.
Yeah, and you've given in a CD or
three copies, and again I sent them the 3 copies again because they took an objection that material.
You have provided in a CD, in a compact disc?
Yeah, CD only.
Okay, I would also request that you, I think, also provide it in a .txt format, because .txt format will always help in opening the sequences. The SQL format, it is a specialized format which everybody cannot open it. So I think
the whole steps also how to open it. I wrote them.
No, but it would be good, as I think I would suggest, if you talk to the copyright office and also provide them in a .txt format. Because in patents, we provide all the biotechnological inventions where sequence IDs are involved. The new genes have been protected. So we provide the sequences in a .txt format.
But,
either in a .txt and a PDF form, both. So if
SQL database we cannot convert in .txt format. It's a structure. So
can you make it as a PDF?
For the other format also, they didn't agree. I told them that
you can make a PDF, I think. A PDF can be made.
Not possible because PDF converting a SQL database in a PDF is not possible. So still it is pending. I am not having any know-how how to take up the things.
I'm surprised because if you can't open any data, even if in patents for biotechnological inventions, if you are not able to open the data, then definitely no patent right will be provided. So, I do not know how this cannot be open. I really, maybe you can separately maybe talk to me, and maybe I can suggest and in what form and format have you provided? I'm really surprised because we do several biotechnology invention protection for the innovators where we provide the sequences in a .txt and a PDF format. Because if these are not being provided in this format, they cannot open it. In fact, nobody can open it. So if the researchers work cannot be opened naturally, it's quite obvious. It's like a handcuff for the office, patent office, or even the copyright office to grant you the registration.
Ma'am, but I asked them whether I should send it some other Excel sheet or something, but they said no, we need only in the native format. So they didn't agree for that because we can convert the SQL database into Excel or Access database. But they said that we need it, we want it in the native format only. So many times I tried to convince them in different ways. I asked them that I will help you out in technical also how to open it. I'll show you and I can help you out.
Maybe you can get connected to us. Maybe we can help you out. So maybe we will see how we can.
Software part we got the copyright because software also I submitted along with that. But database is a special kind of thing. So I thought, and there is a guideline from ICAR that we need to take the copyright separately for it. So that is still pending. And another doubt is there, ma'am, if we have published something, suppose a research paper form, so can we get an ordinary patent after publication?
See, there's a provision in the patent law for the researchers particularly, that when especially people who are doing PhDs, there are researchers who would like to publish their inventions immediately and also would have an interest in filing a patent application. So if you have by any chance published your research in a research paper, in a form of a research paper in a refereed journals, as the first inventor, first and true inventor, you can file the patent application within 1 year from the date of the publication of your research paper. However, we always say that it is better to file a patent application before publication of any research. But if by any chance the researcher is unaware and has published the research paper before filing the patent application, within 1 year from the date of publication of the research paper, one can file a patent application and protect the right.
Okay. And this applies for copyright also? Because if
Pardon?
we are developing some software, suppose, and we host it on our server, and afterwards we ask for the copyright application registration, then is it okay, or we should, before hosting, we should apply for copyright? What is the correct procedure?
No, before hosting, I think you should apply, because again, when you are hosting, it becomes public.
But means whatever.
Because public, once anything becomes in public domain.
They charge so much. For unpublished work, they charge huge amount, and for the published, nominal fees.
Pardon?
Thank you so much, ma'am. I'll personally call to you, and then I'll clear my doubts.
Sure.
Thank you
Sure.
so much.
I will appreciate. Yes. Thank you.
Any other question? Good morning, madam. It is just out of a curiosity that you have mentioned that methods, agricultural methods, and another thing like product variety. So, my just a question that process can be, I have heard long back that not products but process can be patented.
See, earlier before 2005, the patent law was only allowing the process to patent. But after 2005 amendment, which was a major amendment in the patent law, where product patent can also be patented. So we get protection on process and product, which I'm talking about. The 3H is the particular clause, particular section where such innovation which is related to a process of agriculture or horticulture is not patentable. Though it is a process, but there are certain areas or certain inventions which are not patentable under law, which is particularly been cited under section 3, where even if it is a process or a product, but cannot be patented because of certain criteria.
Thank you. So thank you once again. Really, we enriched from your talk. Really highly encouraging to not only women but also all of us. Like you said that there is a reduction in the fees while you file the patent, and then
Yes.
there is a priority in case of examination, early priority is there. So thank you very much, and I'm very happy because we and Anushree did PhD together long back when she was in Delhi, and then she also worked with stalwarts like N.K. Singh and Dr. Mahapatra. And after that, she became a lawyer, patent, and you can see now we heard her talk. So thank you once again. One question that how many one patent can accommodate how many claims for a specification, one patent?
Dr. Sharma, it is that you can, there is a fee involved for filing the patent application, as I told you. For 10 claims and 30 pages of a complete application, there is a one standard fee. However, if you claim more than 10, then each claim has a fee involved. So if you are being as an individual, the fee is very nominal. It's only 1,600 rupees is the official fee for filing a patent application, or being a woman as inventor and applicant. If you are an applicant joint with another male member as an individual applicant, the fee is only rupees 1,600 for filing an application with 30 pages and 10 claims. However, if your claim increases from 10, each claim is fee is rupees 320. This is the charges for an individual applicant filing, a filer who can be a woman or men, or a joint person with a woman. However, if you are filing as an institute or as a company, the fee is rupees 8,000 with 30 pages and 10 claims. And if you are adding more claims, so per claim, the charges are 1,600 rupees, and each page charges are beyond 30 pages. If you go, then each page charges are 800 rupees. So these are the official fee involved, which the patent office takes as per the requirement and claim. So there's no restriction to put the claims. You can protect your rights because your right is protected in the claims only. So as much as whatever your invention is protecting, claims can be defined accordingly and drafted like that.
Thank you very much. So the last slide says that we have to honor women. And just to continue that, at our institute, Dr. Savita Kole has made tremendous contribution in filing many copyrights, many software, and almost 17 copyrights she has been granted. So in the area of the software development, particularly to solve the problem of handling data and also to spread the knowledge of Soybean to the public. Like Soybean Gyan app is one of them, is copyright registered last year itself. So it is a really our, we are very proud that from our institute, Dr. Savita Kole is being recognized in the area of patent, and being a woman, it is again fulfilling the task of today's day. So I would request our director and the chairman of today's session kindly felicitate Dr. Savita Kole for an outstanding contribution, and it's really proud for all of us.
So congratulations, Dr. Savita. My heartiest congratulations to you. I think I will look forward, Dr. Sharma, for more women in the area of biotechnology, life sciences, which your institute already has, to come up with more of research. And I see a lot of women sitting here in the audiences, and look forward. These are young people I can see with smiling faces. So I think they have a lot of energies and know-how to put forward their research ahead and come out with more IP protection.
Thank you. Thank you very much for valuable words and your greetings and appreciation. So at the end, I would request our director, chairman of today's session, to say a few words on this occasion.
Very respected guest of honor today's program, Dr. Anushree. I express my heartfelt thanks and also the gratitude that we accepted our invitation today. And we know that this day would have been invited from other organizations also. But giving time to our organization, we are really thankful and grateful to you. And also I think that you covered this topic, the intellectual property rights, in a very comprehensive, useful, informative way, and almost many things related to agriculture. And with this, I also welcome the other my colleagues who are present on this dais. my colleague from IISR to join this program. And just to speak few words regarding intellectual property. If you see the ICAR, particularly for agriculture research, initially agriculture was excluded from the patent law. Until 1970, to see the 1978, agriculture considering that it is only for the farmers. So the innovations and researches based on agriculture were not included in the patent in 1970. Now in the change scenario, almost everything is now getting patent. Basically, you see the Indian tradition. Here we consider that knowledge is to be shared free. And perhaps on that ground, India was not very, but I say that it was not very aware about this technology, this law for many years. But later on, after independence, it was felt that if you want to promote the innovations, you have to share the benefit which are coming from those research. So later on, several acts were formulated, have been passed through our Indian Parliament. You see the agriculture basically, this plant protection variety, protection of plant variety act, adopted in 2001. This is the first where breeders were actually considered. That even the plants can now be protected, and these varieties, whatever the benefits are coming, they can be shared and so organizations and the breeders to the people. And we hope that there are many other aspects now, not only the IPR, but you see the copyright, trademark, designs, so many things are there, where we can get our technology protected, and we can get the benefits also from that. And in that line, I just our in charge, Dr. Sharma, who has done a very good job in this. He has given me a list of what technology our institute has already licensed. So just to brief you about this, you see that broad weight furrow seed drill was developed from our institute, furrow irrigated raised bed system, subsoiler machine, wheat fertilizer drill from seed planter, fluid seed drill. These are the different machinery which have been licensed to if you want these new Patidar Iron Works, Indore. And then again, some of the specialties where I repeatedly have been asking about this, that we have cleared the value of the soybean as a product. So, very good varieties were bred from our institute, which are ATI 3 and ROX 3, and among them NRC 101, 102, and NRC 109, and NRC 181. These are the varieties already have been licensed to some of the organizations, and they will be producing the seed and using the variety for developing the other valuable products. So these are our contributions, and I hope, and Madam also wanted this day, the WIPO, she has quickly modified it as a woman, the W-word from the word. And I request all young professionals who are here to go through the WIPO website. And you will find so many programs are there. If you are really free without any book, they give the preliminary idea about intellectual property. And you are paid also, and you will receive the certificates also from there. So this is a very good website. You can learn many things about this. And be aware nowadays, because this is the era of innovations and patents about intellectual property protection. Ours, when we were the students, we never knew that we have to protect our technology or we have to commercialize it. It was only thought that it is only for the public interest. So everything was free. But you people have to face the challenges of the present day. And accordingly, you have to keep yourself updated regarding the laws related to our technology development, benefit sharing. And these are the things for the day today. I just was remembering the incident when first time I came here at this institute in 2006. At that time, actually, I came to join one training program on intellectual property at IISR. This was a 1 week program. So we learned a lot. And this was my first exposure to this kind of law at that time. So I hope that not only developing the research, but being aware about what are the acts, what are the laws which are related to this is also equally important. So whenever you get any opportunity to training programs on this, we will also try to conduct some of the training programs further. And you also find we will send people to join such kind of thing. And again, I thank Madam Dr. Anushree for joining and enriching us about the new laws and innovations. Thank you.
Thank you so much for your kind words.
Thank you, sir. Now we come to the end of the program. So it's a time for vote of thanks. So first of all, I thanks to Dr. Anushree for accepting our invitation because 2 days her demand is lot. She may be having 4 more lecture for today because as per the guidelines, only women has to be speaker. So the moment I talked to her, within half an hour, received a 2 phone call from ICAR headquarters that you have stolen our speaker. I said, I already talked to her. So then I told them, this is your program, why you can have some more speakers from Delhi. So thank you very much that you accepted. And thanks to our director, sir, despite of his busy schedule, he could kindly make his presence possible, and all the heads of the section and all colleagues who joined here, not only the scientists, but also the administration and technical and field staff. So it is really a good session we had. So thank you once again. Now all are invited to join for cup of tea outside this hall. Thank you once again. Madam, sometime when you come to, it's our really a great honor and we would be highly thankful if you can make it. You be around Indore, please make a visit to our institute. Thank you.
Thank you so much. Thank you all. Thank you.
Thanks to Yogesh also because he has made all arrangement. Without his help and also the online arrangement made by Dr. Kavita and his team, without these two inputs, we would have not been possible.